Today's case is sponsored by the letter D, as in disclosure, and it involves multiple important matters related to an individual seeking licensure, and in this case, seeking licensure as a lawyer in the state of Georgia. And it also addresses an individual who is the same individual seeking licensure as a lawyer who was licensed as an optometrist. So, first lesson to be learned in this disclosure issue is applications for licensure should seek information about all professional licenses held by that particular applicant and the status of that licensure. So let's get into the facts, if you will, of this particular case. As mentioned, an optometrist with a law degree was seeking licensure in the state of Georgia as a member now of the bar, seeking to become that licensed lawyer. The application, interestingly, began in 2005 when, under his fitness disclosures, his fitness to practice disclosures, which are common among those seeking to become licensed as attorneys in any jurisdiction, he disclosed 6 lawsuits that he had been a party to. And I believe technically he was the plaintiff in these lawsuits. So here's issue number 2 is, how are the questions phrased as to whether you are a party to litigation versus were you the subject of litigation, as in a defendant? So how the question is phrased is also important to allow an individual to adequately disclose to the board, or in this case the bar, his involvement as a party to litigation. So as mentioned, in 2005, he disclosed these 6 lawsuits. And in 2018, he again applied. So I'm not sure what happened between 2005 and 2018. The opinion is not necessarily clear, but he also applied in 2018 and resubmitted his fitness and character disclosures, and he identified additional lawsuits. When the board then sent back in requesting additional information, he also then disclosed an additional 22 lawsuits that he was involved with, and I believe he was always the plaintiff in these lawsuits. He obviously had failed to disclose these lawsuits in the initial application and the supplemental application in 2018. The eventual outcome of this case is the board denied his application for licensure as an attorney because of his lack of candor in disclosure on the application for licensure. So the lesson to be learned in this particular case is, one, is licensed as a professional in other professions should be disclosed, should be asked, by the way, by regulatory boards, and the status of all such professional licenses in all jurisdictions. Secondly is, how are your questions phrased related to involvement in litigation? Might it be as a defendant, so you're sued as perhaps a malpractice or other issue? Or is it you're a party to litigation, which means you could be a plaintiff as well? In the cases that were filed in this particular case, they were all pro se, apparently, so this individual was representing themselves. So, and then the third issue is the disclosure side to this and the grounds for denying an application. The board denied his application. It was appealed up to the Supreme Court of Georgia, and in August of 2022, the Supreme Court upheld the denial by the Board of Bar Examiners related to his application. So, lessons to be learned about involvement in litigation, how questions are phrased on your applications, and stay tuned for further cases that we cover in our reviews.